Today we will discuss different types of contract, and in particular contract of sale, hire of property, and loan. Sale. Sale is defined under section 453 of the Civil and Commercial Code as a contract between the seller and the buyer. The seller transfers to the buyer ownership of property in exchange of a price. So this is a contract, bilateral contract. The seller has the obligation of delivering the property. The buyer has the obligation to pay the price. Let's see in more detail what is a contract of sale. In order to create a contract of sale, there must be an offer and an acceptance, as for any other contract. Ownership of the goods are transferred immediately upon the agreement between the parties. This means that delivery is not necessary. Delivery is an obligation of the seller after the contract is made. This means, to make an example, I can sell you my phone even if the phone is not with me now. I can deliver the phone to you tomorrow. Price. Price is an essential element of this contract. It is usually fixed by the contract or in the manner agreed in the contract. For example, when you go to the market, you want to buy some apples. It may be written 1 kilo, 100 baht. This means if you buy 3 kilos, you need to pay 300 bahts. This is the meaning of this section. What happens if the price is not fixed by the contract? Well, in this case, the buyer must pay a reasonable price. Suppose that you go to eat noodles in the street. The average price is 50-60 baht. If you eat the noodles and you don't ask for the price, the seller of the noodles may charge you 50, 60, 70 baht. But if he charges you 2000 baht, well, in this case, you may refuse to pay. You may say, I do not pay this price because this is not reasonable. If you go to court, the judge will fix the price based on the market price, reasonable price. For the contract of sale, as a general rule, you don't need any particular form. However, if you sell immovable or rights on immovable, such as lands, houses, buildings, you need a written form and registration at the land office. The same applies for ships, steam launches, motorboats, floating houses, and beasts of burden. What are the duties of the party? The duties of the buyer include taking delivery of the property which is sold, as well as paying the price. Duties of the seller include to deliver the goods to the buyer after the price is paid, as well as making the buyer acquire ownership, providing all the necessary documents which may be required to make the buyer acquire ownership of the goods. Also to warrant that the goods sold are free from claim by third parties and free of defects. Let's see in more detail what does it mean. The seller must warrant that the goods are free from defects. The warranty against defects include defects which impairs the value of the property as well as its fitness for ordinary purposes or the purposes of the contract. Suppose that I buy a dog. I buy a purebred German Shepherd dog from you. Later on, I find out that this dog is not a purebred German Shepherd dog. So even if I pay 20,000 baht for this dog, its real value is much lower. The seller, you in this case, are liable for defects. Let's take another example. I buy a dog from you, but this dog is sick. He cannot walk. Well, in this case, I cannot use the dog for ordinary purposes, like for example, running around, protect my property, playing together. Then the last point is when the defect impairs the property and in particular the fitness for the specific purpose of the contract. Suppose I buy a dog because I am blind and this dog must guide me. You guarantee that this dog is for blind people, but actually it is not. Well, in this case, I can sue you because the dog you sold me has a defect. It must be pointed out that the seller is liable whether he knew or did not know of the existence of the defect. The seller cannot say, I didn't know that this dog was sick. However, if the buyer knew of the defect at the time of sale, I knew already that this dog was sick, or the defect was apparent, this dog was not a purebred German Shepherd dog, it was obvious. Or if the property was sold by public auction, well, in this case, I cannot claim any type of defects. I must keep the property and I cannot sue the seller. Another type of liability of the seller is for eviction. What is eviction? Eviction is defined as a disturbance caused to the peaceful possession of the buyer by any person having some right on the property which is sold. Like, for example, I sell you a land, but there is a mortgage on my land. You buy the land, and after a few months, the bank will come to your land, will come to talk with you, and will say, I must sell the land because the previous owner was in default. Well, in this case, you lose your land, but you can sue me for eviction. The seller is liable for the consequences of eviction. This means I need to give you the money back plus interest and damages. However, I may put in the contract some clauses for non-liability. This means that I may write in the contract that I will not be liable in case of defects or eviction. This is why if you are the buyer, you need to be very careful in these clauses that the contract may contain. Also, it must be pointed out that these clauses does not exempt the seller from the repayment of the price unless the non-liability clause specify otherwise. Another important contract under the Civil and Commercial Code is hire of property or rental agreement. Hire of property is defined as a contract between the lessor and the lessee. The lessor agrees to let the hirer to use and obtain the benefit of the property for a specific period of time. In exchange, the hirer must pay the rent. Let's see in more detail what is this contract about. It is a bilateral agreement whereby the lessor must give the hirer the use and benefit of the property hired. The hirer is required to pay the rent to the lessor. There is no transfer of ownership in this case. The hirer is only entitled to benefit from the property for a period of time. The duration of this contract cannot exceed 30 years. Parties, however, are permitted to renew this agreement subject to the approval of the land office. There is no guarantee that this renewal will be approved. Renewal may be tacit, like for example, suppose that I rent your house for a period of 1 year. After 1 year, I still pay the rent and you still accept my money. In this case, this means that we have renewed our contract for an indefinite period of time. This is tacit renewal. Renewal may also be expressed if we, for example, sign a new contract for 1 additional year. What is transfer of rights? Let's see what happens in case of transfer of property. Suppose that you are renting my house, we have a contract of 3 years. Then I sell, after a few months, I sell this house to Mr. B. Do you need to leave the house? Yes or no? Can you still live inside this apartment? Yes or no? According to the Civil and Commercial Code, your contract is not extinguished. This means that you don't have to pay the rent to me anymore, you must pay the rent every month to Mr. B, because Mr. B, which is the transferee, is entitled to the rights and is subjected to the duties of the transferor toward the hirer. In other words, our contract will not apply to me and you, it will apply to you and Mr. B, the transferee. Can you sublease the apartment? Suppose that I rent out my house for 10,000 baht every month to you. May you decide to rent out one room of this house to your friend, which is a student. You can do that only if it is allowed or stated in the contract. Otherwise, you cannot sublet, you cannot sublease the property, you cannot transfer this right over the property to third parties. Do you need a special form when you make a contract of rent? It depends if it is movable or immovable property. For movable property, you don't need a special form. This is why when you rent a bicycle, when you rent a book, when you rent a motorbike, you don't need to sign any contract. This is not necessary. For immovable property, the rules are different depending on whether the contract is made for less or more than 3 years. If the leasing is for less than 3 years, the contract must be made in writing and signed. Otherwise, the contract is not enforceable. This means that the contract is still valid, but it is not enforceable. If there is a dispute between the lessor and the lessee, they cannot go to court. Rules are different if the contract is made for more than 3 years. If it is made for more than 3 years, it must be made in writing, signed, and registered with the land office. Otherwise, the contract is enforceable only for a period of 3 years. What are the duties of the parties? The duties of the letter is bound to deliver the property in a good state, to pay for the necessary reasonable expenses, except expenses for ordinary maintenance, and to pay for the repairs which may become necessary, except petty repairs. For example, if I am the letter, I may need to replace the aircon, I may need to buy a new washing machine, I may need to paint the walls after a period of 5 years, for example. On the contrary, if I am the hirer, I must, of course, pay the rent, use the property for the ordinary and usual purpose. For example, if I rent an apartment as a student, I cannot change the destination of this apartment and making a swimming pool or a nightclub. Also, I must take care of the property as a reasonable person. In other words, as I would take care of my own property. And I must pay ordinary maintenance and petty repairs. This includes, for instance, replacing light bulbs, mending leaks, replacing faucet washers, and sink plugs for my house. Also, if I need periodically to change the filter of the aircon, this is a duty of the hirer. Loan contract. There are two types of loan under the Thai Civil and Commercial Code: loan for use and loan for consumption. Loan for use. According to section 640 of the Civil and Commercial Code, loan for use is a gratuitous contract. This means that it creates obligations only on one party, the borrower. Because this contract is defined as an agreement whereby the lender lets the borrower use the property and the borrower agrees to give the property back after a period of time. For example, if I say, "Can I borrow your car for 1 day?" I borrow the car. After a period of 1 day, I need to give the car back to you. This is a gratuitous contract because I don't have to pay any money. If I pay 100, 1000, 10,000 baht, this would not be loan, this would be rent. This contract is complete and valid only in case of delivery of the property. You can see this rule is different from contract of sale. In this case, if you don't give me the key of the car, we don't have a contract. Delivery of the keys is a necessary element to create this contract. The simple agreement between the parties does not create a loan for use agreement. Also, it must be noted that this contract can only be made if the property object of the loan for use is non-consumable property. It is property which cannot be consumed. I cannot borrow a bottle of wine because after I drink it, I cannot give it back to you. Similarly, I cannot borrow a sandwich. Otherwise, after I eat the sandwich, this would not allow me to give it back to you. Loan for consumption is a different type of contract. It is defined as an agreement between the lender and the borrower. The lender transfers to the borrower the ownership of a specific quantity of property which can be consumed by the user, and the borrower agrees to return the same property. In particular, the laws say the same kind, quality, and quantity. Suppose, for example, that I borrow, in this case, a bottle of wine. I can borrow a bottle of wine. After a period of time, I need to give you the same kind. It means it must be wine. It cannot be beer. The same quality. If I borrow Bordeaux wine, I must give you the same quality. It must be the same Bordeaux wine. And the same quantity. If I borrow 1 liter of wine, I must give you back 1 liter of wine. I cannot give you back half a liter of wine. So this is how it works. The lender transfers the ownership to the borrower, and the borrower has the obligation of returning the same property. The Civil and Commercial Code provides a special form for the loan of money. In particular, Section 653 provides that a loan of money for a sum exceeding 2,000 baht requires a written evidence signed by the borrower. Suppose I borrow more than 2,000 baht from you. You must have a written evidence, written contract with my signature. If you don't have this document, the contract is valid, but it is not enforceable, which means if I don't give you the money back, you cannot sue me, you cannot go to court. As a consequence, if the loan of contract is for a sum of money lower than 2,000 baht or 2,000 baht, the contract is always valid, it is always enforceable in court. For example, you can use witnesses. There are different types of loan of money. It can be with interest or without interest. What happens if the loan of money is with interest? Interest is defined as a remuneration given by the borrower to the lender for loaning the money. It can be property or an amount of money, and it is calculated for the principal debt amount. Suppose that you borrow 5,000 baht from me for a period of 5 years, and the interest rate is 5% a year. The debt amount after a period of 5 years is 7,500 baht. This means interest does not bear interest. You cannot apply compound interest. There are, however, two exceptions. The first one is if it is mentioned in the contract that compound interest must be applied. Well, in this case, compound interest is valid. Also, there is another exception for financial institutions. They are allowed to apply compound interests. How much is the amount of the interest rate? According to section 654, parties they may decide the amount of the interest rate, but this interest rate cannot exceed 15% every year. If there is higher interest rate, then the contract is still valid, but it will be automatically reduced to 15%. There is an exception for financial institutions, and other specific law they may charge higher than 15% per year interest rate. If the parties agrees that interest rate is payable, but they do not mention how much is the interest rate, then according to section 224 of the Civil and Commercial Code, the default interest rate is 7.5% per year. This only applies if the interest rate is mentioned, if the word interest is mentioned in the contract, but the amount of this interest is not specified. If parties they do not mention interest at all, the word interest cannot be found in the contract. The contract doesn't say anything about interest. Well, in this case, it means that no interest must be paid.